So, good evening, everybody. Welcome to this podcast series, which is for the first time started by Fogsi, where every day at 8 o'clock we have a crisp dialogue of 30 to 45 minutes with various experts from various fields, be it medicine, science, and social service also. So, we are very proud that Foxy is doing it for the first time, and it is all the efforts of these 30 chairpersons who are finding out various guests with expertise in such varied fields. And it is only because of their efforts that we as an audience also get to meet such stalwarts. So basically, the theme of Foxy this year is Har Ghar Foxy, and I'm very happy that Sunita madam has just joined us.
Thank you. Dr.
Hi.
Santosh Kakade sir, we are so grateful to you. And I'm very sure not only the Foxians, but every viewer will enjoy this dialogue and will be benefited in the respective capacity. Thank you, sir. Thank you for being on a Foxy platform.
Thank you, Dr.
Thank you.
Sunita. It's a great honor to be with you as well as on this Foxy platform. I'm thankful to you.
Thank you, Dr. Sunita, for joining. Before we start our podcast, let me intro in few words about Sunita, madam. Because she's such a vibrant, dynamic president we got, and everyone is praising not because just because of her leadership qualities, but because of the strict discipline she is maintaining. Everything she keeps in her mind. Today also she is busy in some inaugural function, but she made it a point that Dr. Santosh Kakade sir is there, so she should come there, and incidentally she is with us. And Sunita, today is World Consumers Day. So it is a coincidence that we got Dr. Santosh Kakre sir amongst us. So I think Foxy is very honored because of your presence, sir. And about Sunita, madam, just two lines because she is busy, I can understand. She is our vibrant, dynamic, beloved president. And she's it's a brainchild of our president, madam, that Gyan Pravah, that is flow of knowledge. And this is 46th podcast program today, what we are going to conduct. And she's a very good organizer. She identifies skills and talents, and she tries to here diamond हीरा पारखी बोलते हैं ना हम लोग, वैसा मैडम का है. She recognizes the skill, the capacity, and tries to implement. She's not a leader, but she's a leader of leaders. She makes other leaders. So that's a very kind-hearted Sunita madam. There are many academician, right? We
Thank
can
you.
say,
Thank you, Alka. It's
yeah,
not that I don't have a time and I am on a stage. What
yeah,
is important is today's day evening is between Dr. Alka and Dr. Santosh and not
yes,
about Sunita. So we all are eager to
yeah,
join you all from a different link and will enjoy the dialogue between two of you. Thank you.
yeah.
Thank
Thank
you.
you.
Ashwini
Thank you once
also
again.
says thank you.
Thank you so much, sir.
Hi, thank you, Ashwini, for the
Thank
you
you.
made it
Thank
a
you.
point that the podcast starts at 8 p.m. exactly. So
Thank
thank
you.
you so much.
Thank you.
Thanks. So before we begin podcast, just now I said today is World Consumer Day. So it is our coincidence. I can say coincidence because I tried to call you and gave invitation on behalf of Bhoxy for today's podcast. And the topic we are going to discuss is defending oneself in consumer court. So this is the topic on the consumer World Consumer Day. So we can understand the importance of consumer day as well as the importance of topic. So before we start podcast, let me introduce today's renowned speaker. Actually, sir is a orthopedic surgeon by his medical field in the medical field, but at the same time, he is a self-motivated medical legal person having an experience of more than 25 years in general surgery and orthopedic surgery. He has unique blend of surgical skills with legal knowledge. So that what we call as medical legal, because today we know everybody understands the word medical legal because today it's a need of current era. So he has unique blend of all those skills. He has done PhD in law in an interdisciplinary subject that is changing trends in the law of medical negligence under Consumer Protection Act 1986. We know recently the Consumer Protection Act got amended, but basically, what is the Amendment Act? Whether can be applied to medical profession, what harm it has caused to medical profession. All that was discussed by Kakade sir during his that PhD in that subject. He has analyzed more than 350 cases of medical negligence decided by the Honorable Supreme Court of India and the National Consumer Dispute Resolution Commission. He is an ex-professor of law and management and HOD of Management Department and Director Executive MBA Medical Law and Hospital Management. Maharashtra National Law University, Aurangabad. He was former in-charge president and non-judicial member of the Maharashtra State Consumer Dispute Redressal Commission, Mumbai. He is a professor in law at present. He is a professor in law at Symbiosis Law School, Pune, and presently he is a distinguished visiting professor there. He has top management experience as he has held CEO and other positions as a medical director. He has received many awards. Like he is the only one who got selected for the prestigious award of scholarship it was in 2011 from the American College of Healthcare, that is like Executive Chicago, like ACHE, to attend 3 executive programs in Chicago, San Diego, and Orlando. He has received scholarship by Cleveland Clinics, Ohio, USA, to participate in the executive program on healthcare business management of Samson Global Leadership Academy in April-May 2012. He had visited hospitals in USA between June to October 2012 to observe what are the best practices and what is the quality management in the hospitals in USA. So he had a lot of interactions with the executives there. He was awarded International Fellow Membership of American College of Legal Medicine, Chicago, and was invited as a speaker at the 55th annual meeting in Las Vegas, USA. It was on 26 February to March, 1st March 2015. He has professional affiliations to many medical and legal institutions. And the main important thing I should tell about Santosh Kakre sir, when the Consumer Protection Act was there, we already know that it was in 1986, but because of the famous VP Shanta case versus IMA, it got implemented to medical profession. But since then, sir has tried his best. What was the harm? Why there is an increased load of consumer cases in the court of law, consumer courts? So more of a harm it has caused due to application to the medical profession. So without spending much time on this issue, let us hear from the Santosh Kakre sir about the things he want to discuss regarding how one should defend oneself in the court, consumer court. Sir, the first question I think we should begin because you are orthopedic surgeon, rather you are MS in general surgery and you have done specialized training in orthopedics. So what made you to choose this, it's a medical legal, or you were the in-charge president or non-judicial member of the State Consumer Forum? So what made you to think to choose this line after having a general MS in general surgery legal?
Yes. So at the outset, let me thank Dr. Alka Madam for inviting me. Of course, it is Dr. Sunita, who is the present president of Fogsi, who has been instrumental in carrying these podcasts as such. And I'm very happy to know that the gynecologists, obstetricians and gynecologists all over the India, all over the nation, they will watch, they are watching this particular program and similar kinds of program in enriching their knowledge in different fields of life. Now, since uh, I started my practice way back in 1995 after I completed the general surgery as well as orthopedics in one of the rural areas near Sholapur. What happened was the surgeon with whom I was working, he received those days, of course, 1995 was the year when the Consumer Protection Act was applied to the medical profession. So everybody knows about it. Nowadays, almost all conferences you will find this information which is percolated, and there are uh, as the time advances, there are more and more medical legal experts are coming out, and because of the importance of this particular field. So when I witnessed that the senior surgeon colleague who was harassed by that particular case, of course I tried to help him as well at that time. It was way back in 1996. I decided to pursue a legal education that time, and so completed LLB in 2000, LLM in 2004, and then PhD in law in 2013. Of course, as you mentioned and discussed, that I analyzed 350 cases of medical negligence or the judgments given by Honorable Supreme Court of India and the National Consumer Commission. Obviously, after analysis, the main outcome was that I found, of course, I was guided by uh, the director of Symbiosis Law School at that time. Uh, the main reason why I pursued this particular course, though I was practicing, was I am saying, because right now I'm not practicing as a surgeon. So this was the main point of we can say a stimulus, which took me to this particular path as such. Then 2016, uh, I organized along with the Indian Medical Association one conference, and that conference was medico-legal conference
Yes.
2016, and it was national level conference for which I invited 6 judges, and that time the Director General of Police was Mr. Praveen Dixit sir, so he
Yes.
also was
I was
there.
there. Yes.
Yes, thank you very much.
Yeah.
So this was totally organized by me, and after that, I applied and I got this opportunity to be a member of the State Consumer Commission. Of course, State Consumer Commission means it's a high court of the consumer court systems. So once I got this opportunity, I thought, let me at least have this experience to decide the consumer case. And obviously, we medical professionals are all fearing the consumer courts because the consumer notice of a consumer commission, a single notice also, uh, there are medical professionals who are worried about a single notice from the consumer court as well, because lot many things are happening at that particular point, and when this process is being initiated against any medical professional, uh,
But
lot much support is needed actually to that particular
yeah,
doctor.
but do you think, sir, these few years back, we remember patient safety is our safety was our slogan. So we used to devise safety checklists because
Yeah,
if the patients are safe, naturally doctors will be safe.
perfect.
So it was the like some new technology or new innovative idea which Pune people only brought into action. That time
Absolutely.
also I have attended that specifically that checklist conference. But
Yeah.
do you think? Don't you think that many times this because of the Consumer Protection Act simplicity of the implementation of the act, many
Yeah.
times it is overused or misused against doctor. We can understanding this from the number of cases that are filed against the medical professions. What do you think?
Right, right. Absolutely. So, as you rightly said, is the simple nature of this process of filing the consumer complaint against medical professional. We will restrict ourselves to the medical professional only. Simplicity means what? An application along with the complaint can be filed at the district level of consumer this thing system, and very less fee is there. Bigger amount of fees one has to pay for this particular adjudicating process. So, and the main motto of consumer system was a speedy disposal of the cases, speedy justice. So initially this could be achieved, and then since this was quite simple process, number of cases being filed against the medical professional went on increasing, and in one of the research papers, it is found that more than 450% uh, rise was there, growth was there in filing
Yes.
consumer complaints against medical
Yeah.
professionals. Yeah. So, uh, if you
I think
consider, if you see the what if suppose an aggrieved patient or relatives, what they can do, they can file complaint with Maharashtra Medical Council or Medical Council, they can
yes.
approach the consumer court, they can approach the police station, then they can go to the Human Rights Commission, then they can go to the commonest thing is the media. So there is no control over that. And last one, which we all are fearing, is the violence against the medical professional in hospital. So there are number of ways by which an aggrieved consumer or aggrieved patient and the relatives can voice out their grievances. So it may not be always true that the grievances which they express, possibly there are a number of parameters and factors which are responsible. Due course of time we will discuss definitely.
Yeah.
Please.
But the thing, sir, what I think, suppose some doctor is also human being. If some inadvertent mistake or some harm is there, not purposely, nobody will do like that. But because of that, he has to face 5 or 6 litigations simultaneously. Because
Absolutely.
it is the right of the consumer to go here and there from all the courts, and
Yeah.
one doctor has to face number of dates given by all the courts. So it
True.
becomes as if he has committed some crime, though
Yeah.
it was because of some negative factors or hidden factors or comorbidities in the patient.
Yeah.
And because that some harm can be there, but the doctor has to face the consequences. Again,
Absolutely.
one important thing I would like to ask, there was an amendment in MTP, amendment in Consumer Protection Act. So what amendments means there was a lot of discussion on our WhatsApp groups. Because of this, there is some problem with the doctor because of certain provisions of the amended CPA Act, Consumer Protection Act. So what are these changes that had deep impact on medical professions?
Yes. So
Amended CPA.
yeah, it's a very good question actually. Uh, since this act was totally, we can say, modified, 1986 Consumer Protection Act was replaced completely. This is not an amendment. This is a complete new act. The Consumer Protection Act 2019 was enacted and implemented in the month of July 2020.
Yes.
Now, since this act was published and everybody went through that, usually, in any act, the definition section uh, is there, which gives the details of what what are the different definitions which are being used in the act. In the Consumer Protection Act, in the services section 2 gives all definitions. In the services which will be considered in the under this particular act, the medical services were not seen. So every doctor was very happy that this medical services is not included in that, and that's the reason that time you must be remember that the WhatsApp messages were there. Oh, now
Yeah.
we are out of Consumer Protection Act.
Of the Consumer Protection Act. Yes.
Right, right. So there are certain reasons and explanations why still the Consumer Protection Act, new act is applicable. So though 1995 judgment, this was from Supreme Court of India. It was three judge bench decision, and this was old act was applied, and this decision was not overturned by any other larger bench. This is one thing, and due course of time, the NGOs working for doctors' betterment, they approached Bombay High Court as well as Supreme Court of India, and then clearly Bombay High Court said that it is applicable. So there are various judgments which are available even on the net. And recently, the Honorable Supreme Court of India has also approved a seal of this particular explanation that the Consumer Protection Act is still applicable. The new act is still applicable to the medical professionals.
Yes, sir,
So
but do you think that in the future, if the higher bench or some case is there, whether the
yes,
doctor can free themselves from the Consumer Protection Act in the future?
yes. Ideally, if suppose the representatives of the medical professionals approach once again the Honorable Supreme Court, requesting for a larger bench to come and decide this particular issue, because no other professional is covered under Consumer Protection Act. You will remember that due course of time we have heard that the legal profession is not covered under Consumer Protection Act. Of
Yes.
course, no other profession than the medical profession is still there under Consumer Protection Act. So this can be one of the way by which one definitely one can request. Of course, it's a request because the Honorable Supreme Court's judgment is always final one.
Yeah. But the thing is that, sir, when the doctors, they were used, means in the ancient times, they were like next to God. Okay. But nowadays, they don't consider doctor as human being also. But the professionals, there are legal professionals, there are civil contractors, civil businessmen, many other professions are going on. But if
Yeah,
something happens, some mishap happens, their license is cancelled, they don't get punishment. There is no case like a six courts simultaneously against doctor. So I
yeah,
think there should be some like the amendment is there, okay, but there should be some future progress in that doctor should not be responsible for each and every, because what happens for 6, 10 years, the doctor's life, like he has to attend cases. He has to write drafting, go to advocates, and all these things. In addition to the patients who are admitted, they get wrong impression that there is something problem with the doctor
So
because the
patient
person
engagement.
is going constantly to court. So all this impacts doctor's practice. So I think in
Absolutely.
future something should be there so that doctors should be freed from the clutches of CPA. I think so. And regarding
Yes.
the capping of concession, there was capping of compensation. Sorry, there was some word like in case some inadvertent mishap occurs, then doctors, as an empathetic attitude, can give without any claim that he's not negligent. He's not negligent, but because a part of empathy, no claim compensation like. So no claim compensation, is it a like a rahat disha for future medical profession or next generations of doctors? There should be no negligence case against doctor, but as an empathy, doctor can give certain amount decided by the court of law. No claim compensation, like we can, the term can be given to that compensation.
Yes.
What is your opinion on this, sir?
Comparing to the Motor Vehicle Act, in Motor Vehicle Act, there is one provision of no fault liability, meaning whenever a person meets with an accident, without going into the intricacies of details whose liability it is, the patient is given some amount of initial compensation, a direct amount is given. In case of death also, initial no fault liability compensation is immediately awarded, and then later on the adjudication takes place and the final amount of compensation is decided. Now there are certain nations like New Zealand where no fault liability is being implemented. What is the meaning of that? Now our process is fault finding process. The consumer trial under consumer is fault finding process. What is the meaning of this? The advocate representing the patient brings out what how the doctor was wrong. When the advocate doesn't have knowledge of or ABC of medicine, he comes out with so many allegations. Similarly, those who are defending doctors, they are also advocates. They
Yes.
also take information from the same doctor and then try to defend the doctor. So both sides are represented by the advocates. Okay. Now, the concept of no fault liability, though this is still being discussed among various forums, this can be a better option, as I have already mentioned in my PhD outcome, where rather than the doctor undergoing this very painful process of uh, facing various litigations, there can be one and single window, number one, rather than going into all these courts and all these processes. Secondly, a commission can be there, as it is existent in there are 6 countries where such kind of system is there. Now, commission decides, of course, without following any kind of judicial process. So it has a medical representation, it has a legal representation, and even the judges are there. So they decide what kind of a loss has happened to the patient, and then based on certain parameters, they come out with a compensation. So without discussing what fault doctor had, the compensation is decided, and it is insurance based, or it is known as a administrative based system. The compensation is given by the insurance company. This possibly is the best system because the patient and the advocates do not try to, they, it is not necessary that they try to dig out where the doctor was at fault. In one of the cases, let me just share with you my experience as a judge when I was sitting in the Consumer Commission. Uh, it was an appeal filed against the judgment given by our district commission, and in that appeal, in that judgment, obviously based on the adjudication or hearing, the district commission decided that doctor has no fault at all. Okay. So against that, the patient and the advocate, they filed an appeal and they approached our commission. Now, I was actually surprised the way in which that senior advocate conducted that trial. It was amazing. So that advocate found 22 different grounds. How the judgment of lower commission was
Yes.
wrong, right? So that
Yes.
means it's possible for an intelligent advocate to come out with multiple options. Of course, being a surgeon, I found that they all are possibly not can be the grounds. But
Yes.
then, since I was a surgeon, I was a medical person, I could
Yeah.
have that opinion. But then, when the judge who is sitting there, he also doesn't have the medical knowledge. Based on whatever has been presented and the evidence which is placed before him, of course, the documentary evidence, the member or the judge in the Consumer Commission will decide the case, right? So we were talking about the no fault liability uh, system. Actually, this system possibly will be a good one for all the medical professionals, because this will not discuss any kind of a fault of the doctor, but
Yes.
the patient who has really suffered will receive compensation from the insurance company. So this system, I think it's a actually good system. Finally, why anybody reaches court to get compensation, basically, isn't it? So if that is being given based on a scientific process which is established by the government, then definitely this can happen. And I have actually suggested one additional legislation as Patient Safety and Protection Act, in
Yes.
which rather Patient Protection and Safety Act, it is like that. In that, the interests of medical professionals, as well as, so it's a balancing between the patient's loss and the uh, doctor's liability. It's a balance between the two, and that I think it's a good system which possibly should be implemented.
But sir, do you think that there can be like a reverse, means because the patients or the advocates come to know that it is from insurance companies, so just to get the money, there will be increased number of cases. Can it be like that? The negative impact of no fault compensation. So it can be. There is also possibility because the money is from companies, insurance companies. There can be increased number of cases just to get the money because there is no fault of the doctors as such. Can
But
it be like? Yes.
then still, this will not be discussed that whether there was a fault of a doctor. This is one thing,
Yes.
which is a very good thing. Number two, the commission will decide whether there is a real loss to the patient. So this will based on loss to the patient. This is quite important, and there will be parameters which will take care of the calculation of the compensation. As you just now mentioned, the capping of compensation, like Western countries, still our courts are not awarding huge compensation. There was only one case which everybody knows, that is
Steroid
Kunal
case.
Saha's case, in
Steroid
which
case.
in which the it was definitely Dr. Kunal Saha who could convince the Supreme Court that there was a loss suffered by him, and
Steroid
the
case. Steroid case.
three-judge bench, yes, they heard him at length, and then gave the decision that 6 crores compensation along with the interest 6 crores, so total 12 crores compensation
Yes.
was
11
awarded.
crores case.
But that was the only exceptional case. The other cases, if you go through, they really, the patients who suffered loss, they received around a crores compensation. So if you go through all these cases, I think you will come to know. So as
Yeah.
such, in India, possibly this discussion of copy capping of compensation may not be much useful. That's what I think.
Actually, you are medical person as well as doctor, and that also surgeon. Sometimes I think capping of compensation should be tried because every time there is different methods of calculation of compensation. So it becomes a huge loss for the doctor, losing practice, losing money, and
Yes.
tarik pe tarik. So tarik pe tarik and all these things, it
Yeah.
adds the misery to the doctor's life. So I think
Right.
at places, actually there should be court who decides is there any fault of the doctor. If no fault, then at least some amount can be, they can be capping on some amount of the damage to be paid or compensation to be paid. So it depends upon case to case. Of course, all cases are not alike. I also admit that, but there has to be some capping in the sense doctor should be that he has to treat other patients also. Just because of one problem, one patient, some harm to one patient, that also
True.
not because of purpose. Nobody will do like that. because of some
True.
inadvertent, because of many factors, comorbidities in the patient. If something happens with the patient, his whole practice is ruined, his life is ruined. So this should not
Absolutely.
happen with the doctor.
That is true. That is true.
Sir, one important question many times it is asked in our conferences that I am a doctor, I have a little bit legal knowledge or medical legal knowledge. Can I defend my case in the court of law? And if I can defend, what are the skills I should achieve to go before going to consumer court or court of law?
Perfect.
Can I defend my own case?
So,
Yeah.
yes, yes. So, just to add to whatever being discussed now, myself being surgeon, I was always wondering that in the courts of law, when the advocates do not know ABC of medicine, the judges who are deciding this particular case of medical negligence, they also are not having this knowledge of medicine. Patients is not having knowledge of medicine as well as law. But still, how it is decided that the doctor's liability is fixed and the compensation is being awarded. So how this happens? So I was also always wondering. But then due course of time when I studied law and myself studied for my PhD, I came to understand that there are certain settled principles that come from the various sections of the Consumer Protection Act. We talk about consumer protection only. Secondly, Honorable Supreme Court has given landmark judgments in many cases, giving the principles based on which the further adjudication of similar cases should take place. So, the guidelines from the Supreme Court, various sections from the Act itself, and then previous case laws, so that help in deciding this particular medical negligence matter. Now, coming to the question which you asked, I think in any case, usually advocate represents a doctor. And let me tell you, I have seen many of the brilliant advocates who definitely come forward with, uh, uh, we can say, the crux of the case or the legal aspects of any kind of a medical treatment, so that they bring out and lay before the bench. But if at all the doctor himself wants to uh, defend himself, it's possible because it is the only act in which this provision is there, that the complainant himself can argue his case. At the same time, against whom the complaint is, that person also, in our case, the medical professional, can definitely defend himself. And I'm sure he will definitely be better than the advocates who are actually representing and uh, uh, representing him in the court of law. So in the consumer court, it's possible to defend. Only thing is that one has to know the technicalities. And see, consumer courts are simple, and the technicalities are also not very complicated. There are three stages. First stage is stage of, we can say, pleadings or documents. Complaint is filed by a complainant. Reply is received from the other party, that is in our case a medical professional. There is a time limit for that. So this is first stage. Once it is completed, second stage is stage of evidence, in which in consumer courts the evidence is not lengthy expected, or there is no cross examination as such to find out or to get the evidence in the court itself, but it is to file the documents. Basically, with the help of documents, the medical records are there, medical literature is there, expert opinions are there, and previous case laws are there. These are 4 to 5 documents which both the parties file. And once this stage is over, last stage is the stage of hearing, in where the advocates represent both the sides. And after hearing, the bench comes to the conclusion, and then judgment is passed and final order is given. So this is what is the general technique. There is no much complication as such. So only thing is that the stage one and stage two, you need to take help of any advocate, maybe a junior advocate. But I'm sure the doctors are definitely intelligent. They can definitely quickly they can understand, and they'll be able to defend themselves. Rather, I specifically say that doctors must defend themselves in consumer courts at least, and for which they will need just a simple guidance. And I am actually coming out with a similar kind of actually course or a program which will uh, upgrade their skills in without fear representing themselves in the court of law. So this is what actually I am coming, because this is the need of the hour.
So actually, we many times discuss that legal juries are they have only legal knowledge. The advocates have only legal knowledge. On the contrary, medical legal person has medical as well as legal knowledge. The drafting is very important. What you said is exactly. So if the drafting is good and your defense is good, consumer court, of course, we can go straight away. Only some skills we have to learn. So I think, Dr. Sir, we have started a program in Symbiosis Pune, where
Yeah.
you teach these skills, those who are aspirants and want to study law, not like LLB and LLM 3 years and 2 years course. So they can have
True.
certain courses at different teaching institutes, not only in Pune, but all over India, so that we can gain the knowledge and we have that
Absolutely.
much smartness or daring to defend our own case, because we know what are the intricacies of our medical profession. We can explain very well to judge, and because judge can't argue with this with us for this, because he know, because these are the doctors, they have medical knowledge. But because of the lack of medical legal knowledge and because of fear, deeply rooted fear in our minds, whether I can
Basic,
depend or not,
basic, basic.
there are certain deficiencies, whether there are certain deficiencies in documentation or a
Yes.
communication skill, because we don't know what is communication skill, how to exercise the skill. Though we are experts, but how to exercise the skill, how to
Yes.
write documents properly then and that time only. So all
True.
these things are taught in those classes. I think everyone cannot become law or graduate or postgraduate. But at least
Not
if
needed. Not needed actually. No.
courses, if we can join, definitely we can learn these skills. So one
Absolutely.
important question, sir, because nowadays, many people, they straightway go into mediation or that what we outside the court settlement,
Out of court settlement.
out of court settlement. Yeah.
Yes.
So
Yes.
nowadays, because of the amended amended CPA, there are certain things added in that amended CPA. So what are the things like mediation? What things can give sort of relief to doctors? Yeah.
Okay. Yes. So no doubt mediation is the most important provision which is introduced in the Consumer Protection Act 2019. If you go through the act, it says that for medical negligence matters, uh, in case of death or severe disability, these matters are not to be referred for
Yes.
mediation. So this is
Yes.
clear cut, it is mentioned. But in case of out of court settlement, now to discuss about out of court settlement, when we can say out of court settlement, many a times what happens, the if suppose a death is there, or if suppose there is a some we can say complication that has happened for in case of a patient, the relatives start harassing the doctor, because
Yes.
the only thing because of which this happens is a
Paying money.
patient treated by me goes to my friend who is also a surgeon. He tells the patient that, oh, he has treated you wrongly. And this is the reason why almost all cases or all harassment start. So let every doctor understand that rather than criticizing anybody, this is not going to increase your practice. But definitely, if you are criticizing your colleague, some other day the other person will criticize you. And see, the patients and the relatives, they are just waiting for the opportunity. They will
So
wait, definitely.
doctors behind the doctors, many times the cause for litigation. Doctors behind.
Absolutely. You will find many judgments in which it is written clearly that when the patient approached another doctor, as he told, this litigation process started. So it is also mentioned in
Yes.
the this thing. So when to do out of court settlement? We discussed about that the doctor should represent himself in the court of law. Of course, with
Consumer.
initial support and help, at the final hearing, he can definitely do well. This is what my actually suggestion is. Number two, we are talking about the uh, out of court settlement. So many a times what happens when the relatives start harassing the doctor and they start demanding money. Not only relatives, when they approach the police station, possibly sometimes the constables also give a call to a doctor, ask them to come, and then also demand of money may be there, because this is what I have heard from my friends and the doctors. Another aspect is that the media persons also sometimes get involved. So the society is actually marching towards a different direction, and which is unwanted direction, because of which actually all these things are happening now. In such a case, there is a pressure built up on a medical professional. Now what he should do, it's a dilemma to him whether to settle right now, that means before going to the court or before going to the police, whether that person is demanding 10 lakh rupees, whether I should pay. The answer to it is wait for some time. Try to speak in a sweet language to everybody. Number one, it's not so easy. Huh? It's not so easy under tension. It's a very difficult aspect. But then, see, suggestion देने में क्या है कि you can
Yeah, it is some
always
remedies there.
opine
Yeah.
or suggest. But then this is
Yes.
a remedy I can say. He or she should consult a medico legal expert, and then under his guidance he has to wait for some time. And if that person approaches court, see, out of court settlement is only after the complaint is filed against him in the court of law.
Yes.
So maybe that with the judge's permission it can be done, or else they can settle it outside and come to the, say, this one. Whenever there is a definitely loss and the legal liability is ascertainable against a doctor should not wait, not to get harassed. But for that, insurance company must assist and help, so that the
Yes.
insurance is a far more, professional indemnity insurance is far more important. So when you just blindly signing the agreement, one has to inquire whether out of court settlement is permissible in this particular professional indemnity insurance. And additionally, of course, just an additional thing, uh, apart from medical, this one professional indemnity insurance, one has to insure the hospital staff as well. So hospital errors and omission policy also must be taken, because always if you find that the hospital is the first party and the treating doctors are two, three, four, five, like that, you will find all the complaints. So hospital will have to actually pay the more compensation. Hospital
That
errors and
person.
omission policy, which actually covers even unqualified staff, so that must be taken. So I think out of court settlement, one should not hurry, wait for the right opportunity, because unless you wait, otherwise you are paying hefty amount of compensation initially itself, and again they are approaching the court. That becomes very difficult
Yes.
task for, and losing money is the only possibly outcome of that. Right.
So it means even if there is out of court settlement, the
Yes.
patient can or relatives can go into higher court in spite of
Absolutely.
that. I mean to say.
Absolutely. And
So
another
yeah.
another suggestion is that under the guidance of medico legal expert and an advocate, an agreement should be there. Actually, a kind of agreement should be there that they are settling this case, they have received this money, and they do not intend to approach further the legal system. Of course, this may be challenged. There is,
Yes.
yeah, but still, while
Yes.
going for out of court settlement, ad hoc one should not pay. There must be some document that can be
Yeah.
shown in any court, by which the court may consider this, that yes, this is a proper legal agreement between the two parties.
So always get it written, though it is out of court settlement. Otherwise,
Yes,
patient can go into higher court for compensation again. So it should
yes,
be like documented piece of evidence that patient himself has committed. That his
absolutely,
intention is important. Intention
absolutely,
to go into further court of law is not there. Otherwise, doctor will lose money here also, and again the patients and relatives can go into higher court. So
afterwards also.
that should be clear in the documents. Yes, sir.
Yes, yes, documentation is far more important. If one
Yes.
takes care of documenting the treatment initially
Yeah.
itself, then he need not worry. See, in many cases when the you find, you try to find out where is the medical document. The medical document is absent in the consumer cases when a judge tries to find out. Then, if at all any medical record is placed, no consent is there, or else a standard consent where no name is written, nothing is written, whose
So
signature is there, that is not known. So, in such a kind of a bad documentation, how a doctor can be saved in the court?
yes.
So,
So
one has
my
to
next one is next. Yes, sir. Next
please.
question is on that only. You were the like in city judge previously in court cases, consumer cases. So, what is your experience as regard to negligence cases against the doctor? Means, what
Yeah.
are the experiences you have encountered while judging the cases of doctors in a consumer court? Medical negligence cases, of course.
Yes.
What is your experience, sir?
Of course, see, it is the merit of the case that is always seen, and that always one can, as a judge, it was never that because I'm a doctor, I must rule in favor of a doctor. So, nobody, of course,
Yes.
expected this. Few of the cases, yes, definitely were against the doctors, which I decided. Reason? Of course, it is not my decision. It's the decision of the bench. So a judicial member sitting with me and myself. So we, the bench decides based on the documentation and how the case is argued before the bench. So some of the cases where absolutely documentation was not favoring the doctor, they went against the medical professional. But a number of cases, it was possible that there are certain cases which are known as frivolous complaints against the doctor so as to harass. So such cases could be identified because I'm a doctor. Those cases could be identified and they could be dismissed uh, as such. So it was also possible. So being a doctor, it was a mix of two. Means based on the evidence and the merit, some of the cases were against doctors, but majority of the cases where there was no substance or no merit, they were outright dismissed by our
Dismiss.
bench. It was possible. Yes.
Actually, many times what happens that Amri case, Calcutta case, and steroid case rather, there
Yeah.
was a deficit in documentation only, and
Absolutely.
such a huge compensation was given because there was no documentation regarding patients' observation, OPD finding, treatment, and
Yeah.
Mumbai hospital was expert. The people were expert in documenting everything, so that
Yes.
made a huge difference as far as compensation is concerned.
True.
So every time, whenever medical legal cases or that webinars or some forum is there, we always say documentation of the communication and communication of the documentation. See, it's a
Perfect.
common phrase we use during our panel discussion and our lectures. It's because
Absolutely.
unless and until we are good communicator and good documents we have with us
Right.
to protect ourselves in the court of law, however you are talented, however you are wise in your skills and competency, but
Absolutely.
documents and your communication skill does make a difference. So this
True.
is very important. And sir, something I wanted to listen from you, like Lok Adalat, the Marathi word was Lok Adalat, like out of court settlement. So Lok Adalat and out of court settlement, is there any some degree or difference, some thin margin is there in these two?
See, Lok Adalat is a kind of a system which is alternate dispute resolution system. So that means rather than adjudicating a case, the parties settle the matter between themselves. And the settlement is brought on record. Of course, it is in the form of, say, we can say an agreement, or it is recorded before the Lok Adalat bench as such. And then bench gives final order that this matter is settled between the two parties. So this can be a method by which the out of court settlement is possible,
Yeah.
right? But this is true for the matters which are pending in any
Yes.
court. So if
Yes.
the matter is not at all in any court, see, in one of the cases I remember in Pune, mother of a police inspector, uh, hysterectomy was about to be performed by a general surgeon.
Mhm.
Spinal anesthesia was given, and suddenly there was a cardiac arrest.
Yes.
So what happened? The lady went into vegetative state. Now this is a gross loss to the aggrieved
Yes,
family,
family.
isn't it?
Yes.
So I remember there were so many aspects. So we as a team in Pune, we actually brought together the surgeon and anesthesiologist. So the first step which we had to bring as such as our efforts to settle this particular issue. Then it was discussed with the relatives of the patient, and then finally, after almost say around 10 sessions, it was possible to go for a
Out of
not out of court, but it's a settlement before going to the
amicable.
court as well. Pre-litigation, it was
Yeah.
possible. It was possible. So similarly, see, the way in which you are adjusting or you are accepting the suggestions of the other
Yeah.
party, you need to have that diligence. And the I consider the medical professionals are the having highest intelligence as compared to all professionals. So that should not be the reason for the egos and the
Yeah.
disputes and this thing.
Yes.
No, but rather than that, one has to understand and one has to come out with a very positive outlook to this dispute as such. So that will definitely help the medical professional to come out.
Yeah, so the communication skill, the empathetic attitude, because
Yes,
something has happened to his family, some loss is there, and
yes,
we should think ourselves in their place. If something
absolutely.
has happened in our family, what we will feel? So same
True.
treatment, same behavior, same empathy. If we are, if we can show to the patient relative, many times they will not go into court of law. They will not कि murder किया है doctor ने. These news like a highlighter in the paper,
Yes,
newspapers, and that ruins the practice of doctor. But if he is a good communicator, he has certain empathy with the patient's relative. Definitely,
yeah,
there's a chance that patient's relatives may listen to, because that is like a immediate reactions are like violence and all those things we know.
they
Because
are.
certain things, some mishap has occurred with the family, but at
Yeah.
that time, keeping ourselves balanced attitude, taking the help of medical legal expert, and of course, communication skill. We can't say what has happened. I can what can I do? Your patient was like that only, like that. So such type of language. So good
True,
communicator,
true.
good documentation. Of course, they are
Showing
two keys. Yeah,
empathy, showing empathy.
yeah.
Yeah,
And sir, certain do's and don'ts are of course there, because many times what happen, we read many things when we are PGs or we are having we are learning our skills.
yeah,
But these are practical points. Like nobody teaches us nowadays. We know that our Maharashtra state has given guidelines to give communication skill, ethics in medical profession, documentation. All these skills are taught to PG students before they start their practice. But this
right.
is just beginning few years back. When we were students, nothing was taught to us. When we started our practice, we gradually learned these skills. And because we learned law, it made a difference. But all are not going to become law students. So,
Yeah.
what are the do's and don'ts? Of course, when we start our medical practice, if we want that no medical negligence cases should be there against us, of course, we can't say that there will be zero number of cases.
Prediction is difficult. Prediction is difficult.
Certain predictions or certain things, preventive things, or certain do's and don'ts can be there if at all we want to protect ourselves from
Yeah.
the negligence cases. So, what is your opinion? What are the do's and don'ts?
See, being medical professionals, we are quite interested in the financial management. So it also includes the financial risk management. Similarly, there must be medical legal risk management. What is the meaning of this? What are the do's? There is a medical legal risk management must be there. What it means? Number one, what is going to save you in any court of law is documentation. So even if you don't have time, even if you are a very, very, very busy practitioner, you will have to spare some time to go through the documentation. Your houseman many times documents it, and sometimes if a BMS houseman is there, likely possibility that some of the important aspects may be missed. It's possible. So, of course, I have seen some of the homeopathic and Ayurvedic housemen extraordinarily brilliant, no doubt about it. But the point here is one has to check the documentation. So that is the first and foremost. Secondly, one has to have professional indemnity insurance. And as I have already discussed that apart from professional indemnity insurance being protecting the medical professional, the hospital errors and omission policy also must be taken. So this is a very much important do. So this is second thing. Third, try to find out what guidelines have been given by your own organization. You are a gynecologist, a Foxy, if gives directions that in certain way you have to behave, you have to follow it. Now, what we are lacking is that where the court will look into that what are the guidelines as such, what are the ideal ways of treatment methods as such. For that, our organizations like Foxy must come out with the evidence-based practice, how a gynecologist should actually conduct evidence-based practice, for which the volumes of the uh, guidelines must be available, and that treating doctor must be able to show that based on the guidelines which are issued by our Foxy, I have followed this particular thing and this is what is the documentary evidence that must be uh, done by any gynecologist as such. So this is the next one. And so the medico legal support with the help of medico legal experts, and of course there are multiple organizations which are there to help you. And see, as the time passes, number of additional positive things are coming out. It is not necessary that because one's practice is affected, one should not leave the practice, or one must not follow the defensive medical practice. But positively, one can, with the help of medico-legal risk management, one can definitely continue to practice as a medical professional. So this is about the do's and don'ts. Of course, one of the biggest thing is that
Yes.
please avoid medical jostling. Don't say bad word about your colleague. This is one. But then see, doctors are human beings. It's very difficult to control oneself. So,
Yes.
but then at least they should listen to this important aspect. No medical jostling. Secondly, try to empathize. Don't become rash with the patient as such. Number three, nowadays the advanced gadgets are available. So you can have a 1 minute talk with the relative, record it. See, consent is the biggest thing, and now the days are there when only informed consent is will be accepted. Apart from that, audio visual consent of course will be mainstay, will be mainstay. That's what I think. In case of very difficult cases, one has to record that this has been explained to the patient's relatives, and that forms a digital evidence as per the section 63 of the Bharatiya Nyaya Saksha Adhiniyam, BSA, now which is
Indian.
2023. So one has to actually take care of this. So finally, the days of previous practice they have gone. Though right now the doctors are service providers. So right now doctors are service providers. Still, there is a large section in the society who consider that the doctors are gods. Yes, it is still there. We have to actually maintain our relationship with the our patients and try to give information to the relatives. Of course, in case of emergency, it's difficult to discuss and inform the patient's relatives. In that case, you also must have an advocate. See, I have so many points which I can discuss, and the systems may be available, can be actually developed. So an advocate's role is quite important. When a police calls doctor to come and talk with the relatives or talk with the police people, please see to it that your advocate accompanies you, because the police then are definitely not aggressive. They do not become aggressive with in the advocate's presence. There are so many things which can be advised, and the doctors now must be self, we can say, self-contented or self-sufficient of legal
Yeah.
knowledge, we
Yes.
can say. So they must be self-made in the legal aspect as well, and it is not difficult.
Yes. Yes, exactly. Because what has happened because of these CP and other, because of the increased number of litigation cases against gynecologists and of course orthopedicians, many
Oh,
doctors we just come across, they have stopped practicing. They started, stop admitting high risk patients. Some
yes,
stop
yes.
doing sonography. Some say though then their kids don't want to become doctors in future. They want to become engineers. And most of the talents are going out of India just because
Yes,
they don't want to learn this specialty, medical specialty as such, or become
yes,
doctors.
yes.
So I
Yeah.
think this is like a defensive practice. So better
Yes, yes.
not for defensive
Not,
practice and
yeah.
have a courage. So just
In
here
Pune,
those
ah,
podcast, just two lines for our medicos, just two lines of take-home messages for our medicos.
okay. Uh, Most important is to follow medico-legal risk management. This is quite important. Another aspect is that the systems are available, which they have to make use of it. Try to be ready facing any kind of uncertain situations. It's definitely possible.
Anticipate. Yeah, of course.
Anticipate,
Yeah.
anticipate, because you never know when the complication can happen, and you remain ready to face and document everything. See, the court will ask when you defend yourself, oh, it was an accident. So this happened. But
Yes.
did you anticipate this accident? The court, as a judge, the judge will ask, did you anticipate? And if you anticipated, what preparations you had and where is the documentation?
Yes.
So one has to learn documentation, documentation, documentation.
Yes.
In Pune, we tried actually with the help of retired police officials to prevent violence as well, because violence is such a thing which,
Yeah.
though the acts are available, the central act. So, see, we as medical professionals, we have tried a lot many things, isn't
Yes.
it?
Yeah.
But
Varies
still,
from state to state. Yeah.
still, the response from the government may not be satisfactory. Then why not to develop our own defense
Difference.
mechanism? So, with the help of retired police officials, I try to build certain systems, and I'm happy to inform you that in 10 districts of state of Maharashtra, I could build 50 retired police officials teams. And let me tell you, the retired police officials are gem of a persons. They definitely help the because they understand the principles
Yeah.
which must be taken. The teaching what is to be avoided and how one has to immediately quickly respond. So everything is there.
Yes.
So I
Yeah.
think
So we are just like
that
a
can
task force and
task
disaster
force.
management cell like that.
Yes,
And
yes.
again, yeah,
But
we were,
but in that, doctor must not rush. So we
yeah.
have a we have all this thing that doctors, five, six, seven, or 10 doctors rush to that particular place. But then this may not be of a great help. Rather than that, the others must protect us. Sections of the society, like teams of advocates, teams of retired police officials, they can be definitely. So a system can be in place,
Yes.
so it's possible. Please.
Thank you, sir. Actually, you must be knowing Foxy has developed uniform consent forms for all of us. So we
Perfect.
can just go
Perfect.
on that site and take the
Yes,
help
yes,
of these consent forms. Because
yes,
as you said, documentation is a core skill in addition to communication skill. And by that way,
yes.
we can prevent litigation cases, the medical negligence cases against us. Of course, empathy and what you said correctly, think that you are there in his place. Then we can have good attitude with the patient. And of course, our competence and our knowledge, it also helps that. So
Perfect.
thank you, sir. Thank you, Santosh Kakle, sir. Because of today only, we could learn so many things about CPA, applications of CPA. And we are fortunate to have amongst us because today is a World Consumer Day.
World
So,
Consumer Rights Day.
yeah, World
Yes.
Consumer Day. And
Ah,
at the same time, when we think about consumers, we should think about ourselves also because safe consumers, safe doctors. So,
absolutely.
what safety
Absolutely.
precaution we should take? wonderful discussion with you, sir. So
True.
I thank you I am thankful to you. Therefore, Foxy, I thank you very much for sparing your precious time with all of us. Thank you so much.
Thank you, Dr. Alka Madam. And I thank the Foxy President, Dr. Sunita, for instrumental in this particular discussion. Thank you very much.
Thank you.
Yeah.
See you, sir. Bye.
Yeah.
Rohiji, you can stop the recording.